7 o'clock. I call the meeting of the Board of Appeals, October 18th, 2021. Call the meeting to order. The first order of business will be approval of minutes from the July 19th meeting. Any comments from the other board members?
No comments.
No comments.
My name is spelled wrong. Not that I really care, but it should be, there should be a C in front of the K.
Got it. I was worried about the two N's last time.
Yeah.
I was focused on that. So, okay, I'll fix that.
All right. And I believe that on the paragraph that says first order of business of the board, the last sentence, it should be Levi S. has volunteered.
Got it.
Just for readability's sake, I'd like to suggest that we have different paragraphs where we're making a new motion.
I can do that.
Okay. And that's an extra word on the right here.
Got it.
Motion. Those are just minor changes. Wayne, did you have anything?
No, I do not.
Okay. Do I hear a motion to accept the Emmitsburg Board of Appeals hearing minutes with the
Motion to accept.
slight corrections?
Motion to accept. That.
All right, motion to accept from Wayne. Do I hear a second?
I'll second.
All right, discussion? None. All in favor signify by saying aye.
Aye.
I
Motion passed. All right. First order of business down. Swearing of witnesses. What I'd like to do is anyone who plans to speak tonight, including Leslie, if you're expected to speak or testify at the hearing, must be sworn under oath. All right, please stand. Raise your right hand. Do you solemnly swear or affirm under the penalties of perjury that the response given and statements made by you in these proceedings will be the whole truth and nothing but the truth? If so, state I do. All right, thank you very much. You may be seated. Old business. There is no old business of which I'm aware. Go ahead.
Just one item under old business. I think it'd be most appropriate under old business. Mr. Lind has submitted his resignation, which was effective immediately. And the Board of Commissioners will accept that resignation at their next meeting. So we will be looking for a new alternate.
Okay, thank you very much. There's no motion or anything needed on that, just stated old business.
Correct.
All right. Thank you very much. And we'll take the new business in order that it appears on the agenda. So we'll start with 322 South Seton Avenue. This is a variance request by Robert Stouter. And if I could have a presentation of the case by the staff, please.
Okay, thank you, Madam Chair. This is 322 South Seton Avenue. Applicant and property owner Robert Stouter. Amy, can you turn the volume down a little bit? We're echoing pretty hard. Testing, that's better. Okay. The applicant is requesting 4 separate variances in order to convert an existing garage into a single family dwelling. Variance request number 1 to Town Code Section 1732-070. The applicant is requesting a reduced front yard setback. The minimum front yard setback per the code is 35 feet. Existing front yard setback is 7 feet. Variance request number 2 to Town Code Section 1732-070. The applicant is requesting a reduced side yard number 1 setback. Minimum side yard setback per the code is 12 feet. The existing side yard number 1 setback is 1 foot. Number 3, variance request number 3 to Town Code 1732-070. The applicant is requesting a reduced side yard setback number 2. Minimum side yard setback for the code is 12 feet. Existing side yard number 2 setback is 2 feet. Variance request number 4 to Town Code Section 1732-070. The applicant is requesting a reduced minimum lot width per principal structure. Minimum lot width per principal structure per the code is 85 feet. The existing lot width is 50 feet. Per Town Code variance requirements, Section 1712-050B of the code states that no such variance in the provisions or requirements of this title shall be authorized by the board unless the board finds beyond reasonable doubt that all the following facts and conditions exist. 1, that there are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not generally apply to other properties or classes of uses in the same zoning district. 2, that such variance is necessary for the preservation and enjoyment of substantial property rights possessed by other properties in the same zoning district and in the same vicinity. And 3, that the authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of this title or the public interest. Staff's comments, staff recommends approval of proposed variance requests based on the following conclusions. The board may grant variances by reason of the exceptional narrowness, shallowness, or unusual shape of the specific piece of property in accordance with Section 1712-050A of the town's code. 2, the low-density residential district is intended to encourage and promote the development of single-family residential neighborhoods in accordance with Section 1732-010B of the town's code. 3, the proposed use of the subject property appears to be consistent with the neighborhood and the town's comprehensive plan. And 4, it does not appear that the construction of a single-family dwelling on this lot will cause substantial detriment to adjacent property and will not materially impair the public's interests. So if we could add this as exhibit number 2, exhibit number 1 would be the applicant's application. And that is staff's presentation.
All right. Thank you. Are there any questions from the board members of staff?
No questions from me.
No. No.
Okay, thank you. All right. Now, the applicant will be asked to present his case. Please state your name and address.
Just push the red, the button there, right there. Perfect.
My name is Rob Stouter. The address is 322 South Seton Avenue. And the case is, want to convert that to a single family home because, it's all the rest of the buildings along that street are the same. And at this time, I really have no other function for that building other than to convert it to a house for me. And it would match all the other buildings to the left and the right of that street.
Okay.
What else
All
to
right.
say?
Questions of the
Oh,
applicant?
Maybe one. Do you anticipate any issues? Have you run into any problems or concerns that we should be aware of?
I can't see it. The structure looks great. I mean, there's nothing wrong with it. I can't see it, no, I don't have any.
Thank you.
And it would be for a single family
Single family. Yes.
dwelling.
Yes.
All right. This is probably not apropos to the case, so I'm not even sure if I could ask it, but is there have the gas tanks been removed?
It's been certified by the state by Mrs. Keepers that they've been removed and there is paperwork on that as well.
Okay. Levi, did you have any questions of the applicant?
No, I don't think so.
All right. Thank you very much.
All right.
Are there any witnesses or anyone who would like to, you may sit down.
All right.
Are there any questions or witnesses that would like to testify? Okay. Hearing none. I'd like to now close the record for the board to discuss. The record is now closed. Discussion by the board.
I think we should move forward to approve the findings of fact and the 4 variance requests as noted in the applicant's Board of Appeals application dated September 14, 2021.
All right, thank you.
I'll second.
All right, so we have a motion and a second on the record. Any discussion? No? I agree. All in favor signify by saying aye.
Aye.
All right.
Aye. All right. So we move to approve the findings of fact and the 4 variance requests as noted in the applicant's Board of Appeals application dated September 14th, 2021, as stated in the motion by Dr. Slaughter. Thank you. All right, the second case on the agenda. I've got too many pieces of paper up here. The second case on the agenda concerns 135 Chesapeake Avenue. It's a variance request by Brian and Susan Reaver. We'll first have the presentation of the case by the staff.
1 second, please. Okay, thank you, Madam Chair.
Zach, before you begin, if you don't mind, I'd like to ask a question. Did you intend to provide testimony or? Okay,
She'll need to be sworn in for the I believe she's here for 135. Yes.
okay. So I would like to swear you in now, please. Mary.
You're good to go.
So if you can stand, please. I'm sorry. Is that all right? Okay, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury that the response given and statements made by you in these proceedings will be the whole truth and nothing but the truth? If so, state I do. Okay, thank you, Mary. You may be seated. And we'll first hear the presentation of the case by staff.
Okay, thank you, Madam Chairwoman. So the project description, this is 135 Chesapeake Avenue, property owner and applicant Brian and Susan Reaver. This is in the Village Zone zoning district. First, I'd like to state the existing apartment was not an approved apartment when the property was purchased, and that the change to the apartment was not approved by the town, as confirmed by the property owner's attorney at a public meeting. The town has not inspected the premises due to COVID-19 pandemic. The town will inspect after the meeting to see the alterations. So the applicant is requesting 5 separate variances in order to convert an existing non-residential structure into a multifamily dwelling with 2 units. Variance request number 1 to Town Code Section 1736-060. The applicant is requesting a reduced front yard setback. The minimum front yard setback per the code is 25 feet, existing front yard setback 12 feet. Variance request number 2, Town Code Section 1736-060. The applicant is requesting a reduced side yard number 1 setback. Minimum side yard setback per code is 8 feet. Existing side yard number 1 setback is 0 feet. Variance request number 3 to Town Code 1736-060. The applicant is requesting a reduced side yard number 2 setback. Minimum side yard setback per the code is 8 feet. Existing side yard number 2 setback is 4 feet. Variance request number 4 to Town Code Section 1736-060. The applicant is requesting a reduced minimum lot width per principal structure. The code states it's a 60 feet minimum and existing lot width is 30 feet. Variance request number 5, Town Code Section 1736-060. The applicant is requesting a reduced minimum lot area per dwelling unit. The minimum lot area per dwelling unit per the code is 2,500 square feet, and that should state the minimum lot area with the requesting, not the lot width, is 2,400 square feet. I won't read the requirement of the code, if that's okay, Madam Chair, since I read that in the previous case.
That's fine.
Staff comments, staff recommends approval of the proposed variance request based on the following conclusions. The board may grant variances by reason of the exceptional narrowness, shallowness, or unusual shape of the specific piece of property in accordance with section 171250A of the town's code. The proposed use of the subject property appears to be consistent with the neighborhood and the town's comprehensive plan. And 3, it does not appear that the addition of a multifamily dwelling and 2 units on this lot would cause substantial detriment to adjacent property and will not materially impair the public interest. I'd like to enter this into the record as Exhibit 2. Exhibit 1 should be the applicant's application. And that's my presentation.
Okay, thank you. Are there any questions of the staff of Zach from the report he just read?
No question.
No questions.
All right, thank you. Now, if the applicant could. Wait a minute. Doing this again. All right. Okay, Libby, I'll need to, if you intend to be a witness, I need to swear you in. Raise your right hand. Do you solemnly swear or affirm under the penalties of perjury that the response given and statements made by you in these proceedings will be the whole truth and nothing but the truth? If so, state I do. Thank you. You may be seated. No, 7 o'clock. All right, the applicant can please state their case.
Good evening, members of the board. William Holtzinger for the record on behalf of the applicant. First, we concur with the staff report. I think what you'll see with this lot is probably common with a lot of the lots along that road. They were created before the modern ordinances were in effect. So the lot is 30 feet and you have what you have. The building that we're asking for the variance for is existing. And at one time, my understanding, it had been a tavern for quite a while. So that building is built, in proximity to those different lines where it was. We're not proposing to expand or increase any of the variances. So this project has gone through a couple steps, working with Mr. Golden and Town Attorney Leslie Powell to get to this decision point. So that's why we're before you with these variance requests. I would respectfully submit it does provide for a good use of the property. I think it's certainly probably a less intensive or maybe even noxious use than a tavern, which would still be allowed, as my understanding, under the VC zone. Number of other uses, but I think consistent with the residential uses in this area, this is a better use for the property. I would also note this is not going to give this property owner a leg up on other properties in the VC zone. You have, or the, I guess, village center zone, you have apartment buildings that would not be able to comply with these current regulations, again, because they were built before the modern ordinances. Their density level is much greater than the 2,500 feet. We are slightly, we would be one at 2,488, hence the request for the the slight variance on units per area. So I believe it is a reasonable request. I do not believe it will be harmful to the neighborhood. It is probably one of the better uses I think you could make for this building, because it is a residential use rather than a commercial use in the middle of this residential area. And again, the reason for the variance is because this lot and these buildings were built before the modern ordinances. So with that, Mr. Reaver, did you have anything else to add?
No, sir.
I think what else I'd add is that because this was previously a commercial structure, the water and sewer usage and infrastructure in place, and I would submit that certainly the usage for public water and sewer for these proposed 2 apartments would not be more than what the tavern used. So I think it's not going to have a detrimental impact as far as public water and sewer demand. And lastly, we do have a parking agreement with the Antique Mall, so we're not going to have any, which is right. We're not going to have any problems with parking. So there are factors that you consider. They're in the zoning ordinance. I know I understand there may be some concern with, my understanding is some disputes between Mr. Reaver's tenant and the owner of the other building. Mr. Reaver is trying to negotiate with the other building to eventually purchase it, the neighbor. I don't know where that's going to go. It's not really, frankly, not relevant. But Mr. Reaver is doing what he can to try to resolve that. And to the extent it seems necessary, I would reserve my right to cross-examine witnesses in the hearing. Thank you very much. I would appreciate your approval.
Questions by the board members?
Just a text. Could you spell your last name just for the minutes?
Yeah, it's HOLPZINGER.
Thanks.
Thank you very much.
I have a question.
Yes, sir.
Do you anticipate that at any time in the future, you'll convert from multifamily to a single family dwelling?
I don't think that would be likely, but I guess that would depend on Mr. Reaver. I think once he goes to the point of trying to get 2 units there, he probably would not, but I can't say it would be out of the realm of possibility. But I think just because of the setup of the building, it's probably better set up for the proposed use.
So the future of this building is always going to be rental, is that right?
I would say likely, yeah. Either owner operate it in front, and a rental in the back, or rental for the 3 units.
And with regard to, I have a few questions.
Yes, sir.
With regard to parking,
Mhm.
Do you have something in writing from whoever is providing the space for you? I believe it's the Antique Mall. Do you have something in writing from them that guarantees that parking will be available? There's always a possibility that circumstances will change, new ownership, this, that, and maybe they won't want to give you that space.
Sure.
And that changes the nature of the dynamic. So
Well, yeah, I understand that. I think did you have, what's your nature of your agreement?
I believe he emailed Zach, the lady from the Antique Mall, and she told me she would put something in writing once she knew whether I got approved for 1 or 2 or not. Or
Yeah, and
she couldn't provide. She told me she would reserve up to 6 spots possibly.
yeah, and given the number of parking spaces, I think they're going to have, I think I understand your question, but I think given the large number of parking spaces there, I can't foresee that being a problem, but I do understand your question.
okay, good. I have another question, but I'm gonna let it sort of simmer for a moment or two, so I'm gonna pass it on.
How many residents total do you think?
2.
2?
I mean, 2
2 units.
units,
How many,
but the-
how many,
2 units.
how many individuals could be in those units?
Roughly,
2 apiece, right?
yeah, no more than 4 or 5, I would say.
Yeah.
In the building.
So, okay.
And are these
Certainly don't
these
know who I may rent to or who may be interested.
Mhm.
these units are intended to be 1 bedroom each?
The one, a 1 bedroom for one, and the other one, I'm not sure yet with the design with the contract, but possibly 3 there, maybe 4. I'm not really sure.
3, wait a minute, 3 or 4 bedroom?
Oh, total in the building.
Okay,
Yeah,
so
yeah, I'm sorry,
maybe one unit, 1 bedroom unit, and maybe 1 2-bedroom unit.
Okay. I just wanted to make.
I have a question, Diane.
Mhm, go ahead.
Have you had experience as a landlord with rental units before?
Oh, yes, sir.
Okay.
Very much.
So are you what they would call an absentee landlord, in the sense that you don't live anywhere nearby? And so what's the, call it, the nature of your role going forward in terms of making sure that the tenants are taking care of the property properly and not in any one way or another devaluing it that might impact the neighborhood?
Sure. I've lived here for 49 years. I live just outside of town. This is my business.
Sure.
I've been working for 34 years. I'm self-employed with the type of work that goes into an apartment. And I don't have any property managers. Do all the management myself.
All right.
Is this, is this loud enough to be heard on the recording, or do we need Mr. Reaver to step to the microphone?
I was just about to say that. If you could
Yes.
please step a little closer.
I heard you, but if you could repeat it.
Yeah, if you could repeat it for the record.
Sure. I've lived here in town for 49 years, so I'm not like an absent landlord. I've had rental properties for 24 years here and in Fairfield, Pennsylvania. I do the similar type of work of the repairs that need done. It's all I've done all my life for 34 years, or it's my trade.
Mhm.
And I do not have a property manager. I do all my own managing myself.
Okay,
But as far as finding tenants, screening them, anything like that,
okay.
and
Thank you.
any of that
So
experience.
is it fair to say you're experienced as a landlord and as a property, basically a property maintenance person?
Yes, maintenance as well.
Okay. And you've been doing this for approximately 20.
About 24 years. Yes, over 20 years.
And I have a question. You had mentioned a disagreement, and I'm sorry, my coughing got in the way of my understanding what you were mentioning. So
Well,
what's that
I
about?
will tell you, I really think it's irrelevant, but it's my understanding through Mr. Reaver, there has been some disagreements between the tenants in the house in the front, his tenant and the owner of the house in the front. But that could happen anywhere. That could happen in a single family neighborhood. It could happen in an apartment building somewhere else. So my speculation is some of that might be raised, and I would respectfully suggest to this board that that's not relevant to the factors that you consider for variance. If we meet the requirements, which I believe we do, and again, I would request that you approve and adopt the staff findings if it's by reason of unusual narrowness, shape, design. In this case, this lot, as I mentioned, was designed a long time. These lots were all laid out a long time ago prior to the current ordinances. And I think that's what, would respectfully suggest that's what the board should be focusing on, not, whether some point in time, one tenant had an argument with another tenant. That could happen anywhere. And I don't think it's relevant to a variance request, with all due respect.
I have
Can I
another
get a
question.
clarification on that point?
Sure.
Item 3, that the authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of this title or the public interest. Does that include complaints from neighbors or anything else like that? Is that not at all?
No, sir, it does not. The issues here relate to the nature of the property. So it's not this particular applicant or a particular tenant. The question before this board is whether, in your estimation, the property is such that undue hardship would ensue to any applicant for these exceptions. And so in this case, what they've outlined is that they're not changing the footprint of an existing building and for his ability to use the building for a permitted use in the VC zone. These certain waivers would apply. And then the question, of course, though, goes also to the issue of the number of units because of the math. And I think there's a slight shortage on the square footage for the units to get 2 units as opposed to just one really big unit. So that was a long-winded answer to your
No,
question.
I appreciate it. Thank you very much.
Okay,
No more questions. Thank
If
you.
if I might, there was a great saying, but and Ms. Powell probably remember this gentleman, a former deputy county attorney said something in it, and it's hard to ignore, but he said, you can't do zoning by plebiscite, which is basically you can't do zoning by public opinion. If it's relevant, certainly, but and I certainly understand neighbors having questions, but I agree with what Ms. Powell said. It's, that's what I was getting at. She articulated it much better. You got to focus on the factors that are before you, that are in the ordinance. So thank you very much.
Thank you.
I do have another question. Was there any issue with changing? I mean, I know that residential and commercial are permitted in the village zone. Was there any issue with changing it from commercial to residential? I didn't see anything on that in there.
It's a permitted use.
Yeah, it's a permitted use in the zones. Multifamily is a permitted use in that zone.
Mhm.
I thank you very much for your consideration.
Thank you for the clarification. Appreciate
All
it.
right. Let me just make sure, no more questions from you,
No, no.
Levi.
Yeah.
Okay. Just wanted to make sure.
Yep. Thank you.
Okay. The meeting is now open to the public. Mary, you had signed in first. If you could come up to the microphone and state your name and address, please, for the record. Don't rush. We're fine.
Madam Chair, can I see that sign and sheet so I can get the name down correctly?
Mhm. Forgot we're not right next door to each other.
That's right.
My name's Mary Prater, and I live at 135 South Seton. My side is the side that has 0 space in between. There is an area of about this big between the restaurant and my garage. I've lived in that house for over 20 years, and I rented it for many years. And Anne Marie Boyer Strabinsky said that she always complained. Her father said a judge talked him into letting them put the restaurant right on the property line. It is a huge inconvenience. It always has been. The thought of putting tenants in a building that's this far from my garage makes me a little nervous. We're dealing with people, fire, sound. It just changes the whole dynamics. I know it was a tavern. My grandchildren use the garage for their weights. So the noise was not an issue at that point. But would their noise bother tenants? If they're down there at 10 o'clock at night, 11 o'clock at night lifting weights, that's a possibility. It's just not an ideal situation to have tenants in that house, tenants in that building. One of the things that I was concerned about was overcrowding. So it's something new to me. So I spent some time today on the internet. Some of the things that having people living too close together causes. Fire was the first one that came up with everything. Lack of privacy, noise, and what it does to you emotionally. Every single report that I read talked about the emotional impacts of overcrowding, that it can cause both mental and physical health issues. And just the thought of having 2 tenants down there in a space, when I read the request, he's supposed to have 8 feet on one side and 8 feet on the other. That's 16 feet around the property. He has 4. That's 1/4 of what's allowed right now. When that building was built, I don't believe it was intended to be residence. It was built to be a restaurant. That's what it was. It was Red's Tavern for years. It's just not going to, it's just not desirable. And They talked a little bit about the tenants that are there right now and some of the disputes. When the police were over there on the sheriff's office was there again on 9/16, one of the sheriffs said to me, "Can you help us with this? We've been out here over 50 times since this family moved in." Got to be gun shy if we're going to put more people over there. If we have 50 times that the sheriffs have come out in less than 2 years, 50 plus times. It just doesn't seem to me to be the best way to deal with it. Parking's always going to be an issue. There's not a lot of parking there. I'm fortunate I have off-street parking, but not everybody does. My concern is, what if you put a family in there? You know, a 2-bedroom unit, according to HUD's allowable. You know, one unit allows 2. The second unit would allow 2 + 1. You know, there's an issue there. That's a lot of people in a small space. I don't believe that the space is any larger than this room. And to put 5 people in there and expect it to be neighbor friendly, I think is a lot to ask. And I don't think I went over my 4 minutes, so I'd like to let Libby have any of my extra 4 minutes unless there are questions.
The time that you take is fine.
Okay.
Don't worry about that. So questions for Mary?
Yeah, with regard to your sort of personal experiences of that to date, are you aware of the nature of these complaints? What kind of complaints are they?
Trying to be politically correct. An example would be in the storm in August, our fence blew down. We all have dogs. My dogs ran right through to their yard. Every time that happened, they called animal control. I've paid $225 in fines for 3 visits that my dogs made to their house, to their yard. They were taken out of the yard in less than 5 minutes, but it was still reported. The last time my son went to work on it, he walked past the opening a little to make sure he was in line with the restaurant, because we know that's the property line. And the children started screaming, "Mom, he's in the yard, he's in the yard." You know, they come out, they have their video camera, their phone cameras, they're filming things. I don't walk around with my camera. I don't usually walk around with my cell phone. They're very argumentative. They were that day throwing things at my son. I happened to have been home from work because I had a doctor's appointment, and my dining room window looks right out. And they were throwing what looked to me to be almost like a brick. As it turned out, it was a box for chalk, but I didn't know that. And I immediately called the sheriff. When I went outside, the little girls are screaming and yelling. They threatened to beat me up. They threatened to kill me. They threatened to kill everybody in my family. What I did when they did it is I put on my mother voice and I said, "Young lady, who the hell do you think you're talking to? If you want to talk to me, you get over here." And she immediately turned around and went in the house. But it's continuously like that. What I have resorted to doing is I put film on that window so that when I'm setting my dining room table, I don't even have to see them. It's a completely, if I knew this was going to happen, I'm not sure I would have bought the house 20 years ago or 15 years ago. It's just really changed the whole nature of it. And it's not just my side, it's the other side. You know, we constantly, like I said, the sheriff's out there all the time. This one particular case, I went over to the mother and the mother-in-law and I said, "Ladies, can we talk?" we got to figure out how we can live together, you know? And with that, the sheriff walked up and they said, oh, we called the sheriff. And I said, well, I believe I did first. And the sheriff said, are you Mary? And I said, yes. And they just started going off, and he looked at me and said, can I talk to them first? And then I'll come talk to you.
Mhm.
You know, it's not worth it. And the story, I mean, some of the things that they have said, they've never backed it up. But they claim to have videoed my family in the house. They've claimed to have videoed my granddaughter doing things. I mean, it's like, what are you talking about? You know, it's just, they live in this fantasy world.
Okay.
That
Thank
was
you
my
very
4
much.
minutes.
I certainly can empathize with neighborhood difficulties.
And that isn't the issue. I mean, that is the tenants that are there right now. And I realize
Correct.
that that's not part of the decision-making.
Correct.
By the same token, if that's what we have as tenants right now, we're putting more tenants in.
Okay. As someone who's had deer head thrown in her yard by neighbors, I can appreciate and empathize with your feelings about this. However, it doesn't seem to have anything to do
Right.
with the case.
Except for the fact that there's not enough space for a 2-unit place.
There is a variance requested for the side yard setbacks and the front setback. So,
And I would strongly object. It's one thing to give a variance when somebody is 5 feet short, 4 feet short. We're talking about 12 feet short on,
Mhm,
and if you put both sides together.
mhm.
Only 1/4 of what is required is there.
What is required by the new
Right,
code
right.
that wasn't in existence at the time
What time the restaurant was built.
that the restaurant was built.
Yes,
So, and
that
that's
was-
true of a lot of places in our
Yeah.
town.
but it was, obviously it's, the big white house was subdivided into 2 and the yards were subdivided.
Mhm, mhm. Okay, thank you. Do you have any questions
No questions.
of the witness?
No more
Questions?
questions.
Thank
Thank
you.
you very much.
Thank you.
Thank you, Mary. All right, Libby? Pardon?
These are some
Sure.
informational packages. Thanks so much.
Well, thank you.
Thank you.
Thank you.
Um,
I would love to have, I guess I should start. Thank you. Thank you one and all for serving. Thank you for being here. My name's Libby Briggs. I reside at 137 South Seton Avenue in Emmitsburg. I would love to have counsel here tonight. I did seek counsel. We're at a little bit of a disadvantage in that we had 10 days.
Could you speak a little closer to the microphone? I'm having a hard time hearing you.
Yeah, these masks don't help either. And I have that voice that doesn't carry, except when I put my mom's voice on.
Thank you.
But anyway, we would love to have counsel with us with this one tonight. I did seek counsel. Attorney Paul Flynn is assisting us with this. However, given the short notice, because by the time it was posted with 10 days, it didn't suffice to give adequate notice. Whereas Mr. Holsinger has been in place since December of 2020. So we're playing at a little bit of a disadvantage here. So I would have loved to have had counsel, not been in front of you all, because I'd just soon not speak. Thank you very much. So we live at 137 South Seton Avenue. And then we also have the property that property is 2 lots south of the subject property. And then we also have the property, the vacant lot, that's 2 lots north of the subject property. That's a commercial property. And then we also have the property that's 3 lots south of the subject property on Chesapeake, and that's a residential vacant lot. And then we also have the rental property that's 3 lots south, known as 203 South Seton. The village zone, I think you all know, I walk it a lot. I love it. I love living here. There isn't any place I'd like to live better. It's a wonderful place to live. So that's not why I'm here. I'm not complaining. I love it. This is a great place to live. The property in question, as you know, I'm going to refer to as the subject property. You can find it as 133 South Seton Avenue, and I've put the tax records in there. So as everybody knows, we're on the same page. That's what it's called. It was, just as history, it was converted from a garage at some point in history. And it went down the road of being someplace in time as the tavern. And when the tavern failed, it was a tough market. It sat vacant for many, many, many months, not sure how long. And at that point in time, it was one more tavern, a Red's Tavern, and that was what we knew it as. And there's some pictures in there when it was foreclosed on. The gentleman who had it listed when it sold, we reached out to him, and his name's Eddie Jefferson, and that's on your listing. It's the pictures of the listing when it sold are there. What it looked like is in there, and what he had to say. I wanted to make sure that I didn't miss something. Did I miss something? There was, so he has it in there, what he had to say when it sold. It had, he said no work had been done to the property since the ownership by the bank. So we all remember it the same way. It had a commode for the women, a commode for the men. He called it a half bath, but it did have a partition for the men and a partition for the women with a commode. And it had a sink outside as a joint sink to be used. It had a commercial kitchen and storage as it appears in the MLS pictures. And that's about it. According to the letter from the town planner to the current owner dated 12/20, quote, no zoning certificate for work has been issued for any work since the 2019. Therefore, the town planner stated the property must cease using this structure for residential purposes by January 31st, 2021. The owner's attorney is on town record as stating the apartment was not in the tavern prior to the current ownership. The town ordinance, whether modified or not modified, because I'm not sure which one we're playing by, because we had the original a date that we were given this letter, the owner was given this letter in December of 12/20, and we were supposed to cease use January 21, but yet now we have a modification of August. I'm not sure when that went into existence. Zach, can you help me with that? What playing field are we on with this particular modification, this town ordinance 1708190? What playing field, what are we using for our definition? Are we using the second paragraph or are we going with the August?
I'm sorry, what was the code section?
17.08.190. I just wonder what we're using, what definition we're going to use for this particular decision. Because it significantly impacts how we're going to rule on this tonight, or how we're going to make a question. because the second paragraph that we're omitting, if we're going to rule on this tonight, is that we're going to rule that, because if we use that second paragraph, because if we're going to use the January, I'll let them decide what one we're going to use. We've got, what I'm asking is that we've got a letter that went out and you said, as the town planner, cease use of residency, cease use of occupancy.
I'm sorry, is the board directing a question to me? Everybody's looking over here. I'm not. Really-
I'm sorry.
Not really the way it works. She doesn't get to ask questions.
No, I don't.
Right.
I'm asking the board, what, I'm sorry. I was hoping Zach could help us.
Are you referring to the letter of December 8th, 2020, paragraph B?
I left my notes back there, but I am referring to whether or not the town is, I did reference the modified because given the scenario of how long this has dragged on, because that's 12, that letter was issued 12 December 2020.
Mhm.
Okay, so we were under a different ordinance then. We have a modified ordinance. So I respectfully request that the chair request to these folks to my left what ordinance we are dealing with, whether we're dealing with the modified ordinance, which has a different context, because at that point we would be removing a paragraph, because this particular, the particular hearing request, although the planner's original letter that went out
Mhm.
then and requested that this cease, this residential use cease,
Mhm.
January.
1708, let me please look it up.
Thank you for looking it up.
Number 8, aren't you? That's the letter.
Pardon,
we have
I'm looking at a letter from December 8th.
Yeah, that's the one
From
we have
Zach.
attached. Yeah.
Yes, okay. So I'm looking up 1708, 190.
190.
Mhm.
And the question is that second paragraph, which says there shall not be, irregardless, it said, I'm going to just read.
Let me,
Get
Let me
to that
find it.
paragraph. I'm sorry, I didn't provide that to you. I should have.
sorry.
It was a debate whether I was providing too much or too little. I apologize.
Okay.
Because it is about the definitions that we're dealing with.
Okay, so those are the two paragraphs that are quoted in 17.08.190.
But that has been modified as of August.
Okay, that's what I don't have the latest code.
But
So,
which, my question is, which game plan are we on? Are we on that game plan that you are with? Because that would have been based on the letter, the original letter. Is that the game plan we're on?
what I need to know is what the code has been modified to. So I'd like to ask the planner, do you have a copy of what the code has been modified to? And if so, could you please provide that for the board?
I can address the immediate question, which is what code applies. The
And
code-
again, could you please put your microphone a little closer to you?
Sorry.
Just,
And
yeah.
the whole mask thing doesn't help.
I know,
that.
it's
No,
hard.
it doesn't.
You can, apparently you can take it off.
Oh, you
if
can?
Prefer when you're behind these.
Oh,
Better
okay.
Now that you're closer to it.
Yeah, it is
It
better.
really is.
Yeah.
Mhm.
Just
Thank
speak
you.
closer to
Just-
the
Oh, it
mic.
is. Oh, okay. Yeah, I'm sorry. Trying to keep up with all the rules, I get confused.
I know, I do
Oh,
too.
thanks for joining me.
So the answer, the immediate answer to the question is that The code that applies is the one that is currently in force.
All right.
All right, under the prior code, the conversion to a residential use was not permitted. That code was amended. The text amendment process was followed, the application was filed. And the code that now applies is apparently not the one that's in your hardbound book,
Right.
but has been changed. And I believe that you're going to receive the updated versions. But that's the set of rules that applies. It's standard procedure. And that's the way the rule, that's the way.
For
the law
this
works.
case that we're deciding
Yeah,
tonight.
current law applies.
So the application is in compliance with the current version of the code, is that right?
Yes.
No,
Yeah, there's nothing wrong with the application.
well, the application is in compliance, of course. But if I could just ask everybody to take a look at this one section, 17.08
No, it needs to be-
dot 190. And it says no garage, shed, outbuilding, or other non-residential structure existing on the lot at the time of the adoption of this title may be converted to residential use unless said structure is able to meet all of the requirements by the zoning ordinance, including but not limited to lot area per family and front, rear, and side yards. No variance or special exception will be permitted to expand a non-conforming use. Now, there was no conforming use at all. I mean, we've already established that because we didn't have any permits. We don't have any permits. The town planner requested that the property be vacated. And we're going to go on and find out why. And I'm happy to go on. If you'd like me to pause, I can.
Diane,
Yes.
I believe Libby's asking for guidance.
Pardon?
I believe Libby's asking for guidance. Would you like her to continue on?
Oh, I
Not
can
right
pause.
now. I'd like to
Sure,
finish reading this so that
sure.
I'm sure what's been changed.
It's the second paragraph that's been changed. The second paragraph was omitted. The first paragraph remained the same.
The second paragraph is still in my copy of this.
Oh, I'd like that. Can I have that one? I like that.
Is this,
I like that a lot.
is this the most recent version?
1 second, please.
Okay, thank you.
That wasn't the one I found online.
Make sure I read it completely. Because this looks like the same thing.
The online version has the second paragraph omitted. Everything else is the same.
Excuse me, I'm sorry. I think the confusion goes to whether or not it's a non-conforming use. It's not a non-conforming use because the use is permitted in the VC zone. Multifamily is a permitted use in the VC zone, which is what this property is zoned as. So what this goes to is a modification of the setback criteria, and the building has already been constructed. So there's a distinction there that's material for the purposes of this board's consideration. It's not a non-conforming use, it's a conforming use within the village code.
Okay,
Does that make sense?
May I just,
so. Yes, I'm sorry.
no? You
What-
can, but it starts with conversions of garages, sheds, outbuildings, or other accessory structures. No garage, shed, outbuilding, or other non-residential structure existing on the lot at the time of, and then it goes on.
Okay, and my understanding, or from what I'm looking at, is that it's not a shed or an outbuilding. It was a business.
Was a business that was
Correct.
vacant for many months, so it was nothing.
But the business then didn't turn into a garage.
but it was nothing. It could not get a permit. You could not re-permit that business.
That's actually not part of the record.
Okay. That's not part of the record that we're dealing with tonight, or it's not part of the record?
It's not part of the record that we're dealing with here tonight. I have
Okay.
absolutely no knowledge of whether or not the building could have been recertified or certified as a restaurant business, because there's a whole different set of rules that apply to that. The exception is given to the property.
Again, please.
I beg your
Thank you.
pardon. I'm sorry.
It's okay. Just lean it
Yeah.
forward a little bit.
Sure.
Yeah.
There we go. The exception is given to the property, and the non-conforming use issue goes to the use. And in the VC zone, once again, multifamily residential is a permitted use. So just banish that whole concept from your mind, because it doesn't have any bearing on the request for the variance relating to the setbacks.
Okay.
That's all I'm trying to say.
So the variance for the setbacks is what we need to be looking at. All right. And due to the unusual shape of the property and the fact that it was existing already before the codes were put into place. I mean, well, I'm having the discussion with the board, sorry. Means that the fact that it was a restaurant has no bearing on it whatsoever. It's a permitted use in the village zone.
I think that probably the best course of action, and excuse me for interrupting you, Madam Chair, but the best course of action is to allow Ms. Briggs to finish her presentation, and then it can come to the board for a motion and discussion,
Thank you.
and possibly rebuttal by, I guess, by Mr. Holsinger and his client,
Right. All right.
or cross-examination.
Sorry, did not mean to interrupt. I'm just trying to make sure I understand all the,
Understanding
you're
is an
making.
excellent process.
pardon?
Understanding is an excellent process. That's an excellent process.
Working on it. So, go ahead.
The town, I'm just going to keep going. The town hasn't, if you want to stop me, stop me. The town has an obligation to provide safety to each of us as residents. In a search for permits through the county, none could be located on the subject property, and reportedly none exist from the town. And no public official has been into the property for inspections. Just wondering how the Board of Appeals meeting for residentially occupied property that received a cease to occupy as residential notification December 2020 with no permits can continue with a variance. I hear Attorney Powell, but it's still questionable. In my own mind, under the safety, given the scenario that we're now here listening to a variance for a second unit for a residence that doesn't have any, and there were 10,196 residential construction permits issued in 2020 in Frederick County. We still have a safety issue to contend with. And because that is our most serious concern. Being personally involved with Emmitsburg Business and Professional Association in multiple fires, one including 31 households at one time from the square corner, their relocation to temporary and permanent residences, common sense speaks loudly to us that this is not a safe way to allow a property to proceed, or any property to proceed, not just this property, but any property to proceed. Town planners notification 12/8/19 stated the owner must cease. I'm not going to keep going down this. We've addressed it, but the issues 12 Town Code 1712.030 may be one of these codes where it states specifically that a BOE hearing is Board of Appeals hearing is to occur within 30 days after the time that the owner was to receive the notification from the town planner. that date of the original letter to the owner was received in on December 8th, 20. I'm getting my dates all mixed up. 2020. Thank you so much, Mary. 2020. So we're at 260 days now. Later. That's a long time for 30 days. Now, I'm not sure what happened between then and now, but it's a long time. It's nice to have the appeal now, but we do have a 30-day appeal process because that's what the letter stated. And it also states it in the town ordinance that there's 30 days. At least that was my understanding of it, and I'm happy to be wrong. Town ordinance is for safety for the delivery of the appeal process. The overcrowding in the 20 years, overcrowding is a tremendous issue. In the 20 years that I've lived on 137 South Seton Avenue and had our office there for almost 30 years, never experienced the police calls from 50 to 80 times they've been called to that block. It is staggering to live through, and it's an even more staggering use of the police and staffing of the tax dollar, and it stems directly from overcrowding. Peaceful enjoyment of our interior and exterior is significantly diminished, and I hear a big sigh from behind me, so sorry. Overcrowding flows to parking. The parking is on every lot on our street from Chesapeake to Potomac. Every single lot has parking except for this lot, except for the subject lot. And parking actually runs right on down to the post office. Everybody has parking except that particular lot. So it just once again speaks to the overcrowding, and overcrowding leads to issues. And there is a significant issue pertaining to the demographic, the irregularity of that lot. And although, and I do think that the Board of Appeals has the right to say and speak out against overcrowding, over safety. These are issues that we believe in. The owner's MLS demographics state that the town of Emmitsburg has an average of 2.7 people per household, an average 1 to 2 adults in the household equals 1 to 2 vehicles to park. Just wonder where those are going. Urban Land Institute Senior Fellow Ed McMahon spoke a number of times to the Emmitsburg Business and Professional Association, stating residential expenditures use 95 to 98% of the public tax dollars compared to commercial tax income, produced a higher tax income with lower percentage of public usage. So there's no possible way that our tax dollar is going to be benefited by the use of these units as apartments. It's not. It's going to take more revenue and more use, as it's already done. These units have taken a tremendous amount of revenue and a tremendous amount of use. In the package for this agenda, the town planner cited properties with similar variances, such as examples 321 to 317 and 217 West Main Street. I would venture to say, you know, in a quick research that I had time to do, these properties were in existence the 30 years that I've been coming to town. None of them have applications or have properties that have detached units that are going for waivers at this time. And none of them have the specific irregularities that we're dealing with. And none of them have the sensitivity that we have with regards to the semi-detached and attached units that we have. So I hope that each of you had the opportunity to take a look at those. And if not, I wish that you would before you made a decision, because it's important. Because when I looked at them, I was like, whoa, those are like apples to apple or apples to oranges when people talk to me. Hey, lady, you're comparing apples to oranges.
Okay.
Emmitsburg has a great town staff. What happened between December 2020, when the town planner issued a letter to cease using the structure for residential purpose, by January 31st, 2021, and all these 260 days later, where we are here at the Board of Appeals meeting requesting an additional residential unit for a property with no inspections and no use and occupancy permit. It's interesting, to say the least, and questionable at the outset. Consider we have strong and multiple number of commercial and residential people around us who have asked us to express this. Some of them are concerned about, they're just concerned. They're concerned for various tiered levels of reasons. It can be a challenge with retaliations and things like that. So we can experience things that we don't want to. But please, first and foremost, consider the safety that we ask for our overcrowding and how it spills over with the cost for the fire and the police and even individuals who park in the wrong place and then have to pay for having their cars removed. And then the precedent and the example that we set to the community when they see the complete disregard for permits and ordinances. And we ask you to place this structure back to what it was. So we thank you. Emmitsburg is a great place to live, and I thank you for listening to me.
Thank you.
Thank you all for your.
Thank you.
Actually, I would have some cross-examination.
All right. Yes, I was about to open it up for you. Please come up to the mic.
I don't know how to carry this out. I guess Mrs. Briggs will have to stand up here too as well.
You can talk to us.
Yeah. So, well, no, I have to ask her the cross-examination.
Okay.
1 second. Amy, do we have a mic we can give to Miss Briggs, Mrs. Briggs? Okay. Yeah, if you could
Yeah.
just take turns at the mic, I'm sorry.
All right.
So if he would ask you a question, if you could go up to the mic and answer, please.
Ms. Briggs, you were aware this was going through the process for some time now. Is that correct?
Sir, to be honest with you, it was.
You need to step to the mic. So we need to make sure that we're recording all of this. So
To be honest with you, how do I address, do I address you? Do I address Mr. Holsinger? How do I-
you
how do I
can
do this?
answer his question.
I can
The
answer-
question that he asked you, you can answer it. You can talk to us if you'd like, but you need to answer the question
Okay,
that he asked you.
this is confusing. Sorry. To be honest with you, sir, it was 10 days ago that I saw it posted. And then I didn't see it on the website. And then when it wasn't on the website, but the first case was on the website, then I called Zach. And then on Wednesday, and I said, oh,
What I asked you.
Okay.
Is this, you were aware of the zoning text amendment for this case?
no.
So you had you're stating today you did not realize this property was requesting a zoning text amendment.
No.
Okay, let me move on to something else then. So the witnesses said she had no knowledge of it. You're in the real estate business, is that correct? You have been? Okay, and you're aware of the village center zoning in the town of Emmitsburg?
Part of my first statement, sir, I love it.
Okay, and so you're aware that village zoning allows multifamily, is that correct?
Now, careful where you go with this, sir.
I just asked you either you know the answer or you don't.
Mr. Holsinger,
Do you know whether village zoning, it's a simple question. I'm not trying to be rude. I just want to know if you understand that this zoning allows for multifamily use.
you know, I answered that question in about 20 different ways here, sir. And I answered it.
Do you, is it your understanding?
Nope, I'm not
So-
answering that one, sir.
Okay, so you're also
Back
concerned of,
counsel, I'm not answering that.
you're also you've stated that you're concerned about overcrowding. Is that correct? And you're stating even from the houses that are there now that you're concerned there's overcrowding with the existing village zoning that's there now. Is that correct?
I appreciate your questions, Mr. Holsinger. I'm not
Okay.
answering anymore until I get an attorney with me.
Okay. Yeah, I would move to strike. If it's not going to answer, I just would move to strike the testimony. So
Mr. Holsinger, I'll answer them only if you'll allow me to answer them, not in a way that
I'm just
doesn't-
trying to avoid long, I'm just gonna move on and go rebuttal because I'm trying to just
Okay.
get right to the point. And I'll just address it in my rebuttal. Thank you very much,
Okay.
Ms. Briggs. So if I can go ahead with my rebuttal.
Yes.
So I fully have respect for Mrs. Briggs' concerns. Obviously, you want people that are concerned about the safety, but permitting, we've been going through a process for quite a while now. This was a stepwise process. We first had to get a text amendment. And then once we saw what happened with the text amendment, the next step was come here. And that's what we've done. So whether there's a permitting or violation issue, that may be, and that'll have to be addressed. And that's the reason that Mr. and Mrs. Reaver are going through this process. Village center zoning allows for multifamily use. And the reference to the other units up here was not in reference to the variance for the setbacks. It was in reference to the square footage allowed, because in those apartment buildings, obviously, they are much denser than one family unit per 2,500 square feet. So that was the purpose of the reference to the apartment buildings. And my point is, there's many other examples here. We're barely below that, as counsel for the town pointed out, we're at 2488. So that's a very minor variance request. And in comparison to many other properties that have village center zoning here, they are at a much greater density than what we're requesting. So while I fully understand all the comments, again, I think you need to, or I would respectfully request that the board focus in on the factors that you consider for these type of requests, which is by the unusual shape of the lot. It's not so much unusual. It was a 30-foot wide lot approved well before these ordinances. This building was built well before the current ordinances. There's little the owner can do. And I would not suggest that having a tavern there again would be a good idea for any of this. And frankly, with respect to overcrowding, there's existing houses right next to each other. Even the lady that testified for her house is within 2 feet of the house that's there, and she's lived there for 20 years. So the houses, they are close to each other. That's the neighborhood. That's how it's been built. And I don't think we're requesting anything that's any different than what's very much the characteristic throughout that street there. So with all due respect, I would request that you focus in on the standards for granting variances, which are due to the shape of this lot and the fact this is an existing building. There's really nothing the owner can do to change that. And they don't propose to expand the footprint at all. They're not going to increase any need for variance. They've addressed the parking. And again, the owners, the applicants have gone through the process in order to address the notices from the town. And we do absolutely appreciate the ability to work with the town. And if there's other actions that have to come, I think we'll have to deal with them to come, but I don't think they're relevant to the variance request. It's a different issue. So I thank you very much for your consideration, and we respectfully request approval of these variances consistent with the staff recommendation.
Okay, thank you very much. Without further statements by anyone, I'd like to close the record so that we can discuss it as a board. Zach, I would also like to ask that the papers that Mrs. Briggs brought in would be entered into the record.
Yes,
as
please,
Exhibit.
as Exhibit 3.
Mhm. Yes, please. All right. So it seems to me that we're looking at a recommendation by staff to approve the proposed variance requests. We have heard from two witnesses. Discussion, questions?
Go ahead. I have a couple, but go ahead. I mean, I get both sides. I get both sides for sure. It'll be interesting to see if approved, what the restaurant will look like. And yeah, because I think it is important when it comes to, to space, when we're talking about zones and we're talking about square, the different setbacks. I think the inside's important too, because I think when it comes to safety of all the residents, I think it's important. But I think there's a lot of tight spaces around Emmitsburg when it comes to some of these things, and so I'm not sure where I'm at, but I'm sure that there are setbacks that are similar setbacks that the staff would agree to.
Even with 0
Yeah.
side yard setbacks.
Yeah.
There
Yeah.
are properties like that.
Yeah.
Based on the fact that the town was put together back in 1800s, so.
Yeah.
Yeah, and we can't make any zoning decisions about the inside.
Yeah.
So
Yeah.
we don't get to say anything.
No, I know.
about that.
I know.
And we don't get to say anything about who gets to move in.
Yeah.
Or, or what kind of situations have gone on with neighbors.
Yeah.
That's not something that we have the ability to adjudicate here. We have to just see if these findings of fact say that we should grant these variances.
Yeah.
So you're not sure which way?
I mean, I think I probably know which way I'm going, but I feel for both sides. I understand both sides. And so knowing that area, I know that, I mean, it is right. Cause when there's baseball tournaments over there, I mean, that house is right there. And so I know the parking situation. I understand all that. So I know how cramped that space is. So I understand that side of things. So
I would like to ask a question of Zach. Zach, Mr. Holzinger asked you about whether there was a formalized agreement on the parking. And I thought you said that she was going to send you an email
Right.
after the case.
No, she did send me an email. Mr. Reaver is correct. We do have an agreement between the Reavers and the Antique Mall. He's provided us a copy. So he does meet that part of the zoning ordinance, which is not a part of this case. However, he will meet the parking requirements.
It has bearing on this.
Yes.
case. Yeah. So there is an agreement already.
There is an
We
agreement
Have documentation of that.
from the Antique Mall, signed letter.
Okay.
Yes.
Okay, thank you.
Is it something to discuss about what's in the letter and the 30-day appeal letter? I'm not clear. Did they not submit a letter within 30 days?
The letter that Zach sent to the Reavers
Mm-hmm.
was based on disallowing the use at that time.
Mm-hmm.
Since that time, my understanding is that the Reavers was working with the town staff to fix the issue. And so that was why the Board of Appeals didn't happen until that text amendment was passed, correct?
That's correct.
Okay, so that
Okay.
was in process. So it kind of held the clock. I understand what Libby was saying about the
Okay.
30 days, but it seemed to me that the work that was going on with the town staff held it.
Okay.
So I'll put a stop on it until
Okay.
this time.
And that letter, excuse me for interjecting, but that letter
Mhm.
also isn't the subject of this petition tonight.
Pardon, I'm sorry. I didn't
That
hear you.
letter is not the subject of the application. That letter related to a different issue.
Right,
So I think there was some sort of general confusion, if you will, as to why we were here, because it wasn't in response to that particular letter.
no, it wasn't.
I just
That-
wanted to
But
make
that was
that clear.
included as part of our package.
Right.
To give us the context, so we were aware of that letter. But the reason we're here is to determine whether or not to grant these 5 variances. So, Wayne,
So, I'd just like a little clarification if I could get that from Zach and council, please. We were given this, what is it, 17.08.190, and then below it, 17.08.200. This document here, for what it's worth, starts with conversion of garages, sheds, outbuildings, or other accessory structures. And as was brought up under A, no garage, shed, outbuilding, or other non-residential structure existing on the lot at the time of adoption, this title may be converted to residential use. And then it goes into B. It says, because this requirement does not disallow the use of land for purposes set forth in this title, it seeks only to prevent the overcrowding of the lot and the neighbor or the environmental degradation of the neighborhood. The Board of Appeals is not authorized to grant a waiver or variance to this section. Can you explain that?
Sure, that doesn't.
That's fine. If it doesn't apply and it has nothing to do with us, that's good.
That's the answer.
All right. Okay. So we can disregard that language. It
that
has
is-
nothing to do with us.
Correct. The way that these cases are decided is based on the law existing at the time of the hearing. And the law existing at the time of this hearing is as it is currently codified.
Right.
And so
So
this is the one that
190,
applies.
which is no longer in effect,
The,
right?
the one that you just recited is no, it's
190 is
kaput.
No longer in effect.
That is
So we're only
correct.
concerned about the current version of this, and that's it. So that statement there is no longer relevant.
That is correct.
So I have, do you want to ask a question? Doug?
Oh,
'Cause I have a,
yeah, just because, so why we don't have a copy of the correct one?
That I can't answer. But
If
it was
that
amended.
paragraph B was stricken
Mhm,
and these are our updates,
that's correct.
That's correct. So you were getting those after the meeting tonight. However, since the reason why we didn't give it to you the exact date that it passed, because it has no bearings on this application. This, as Leslie stated, that was the law from that application time period. So it has no bearing on this case. The variances are permitted to be applied for now. Before, you couldn't even see the case. Now you can see the case because that text amendment has passed.
okay. All right, so the fact that it's still here on our document,
yeah.
And
I just
hasn't been
want-
updated,
I
we
want
can
a
just-
Clarification on that, because it's obviously a concern, and it claims that we have no right to make the variance requests for what it's worth. And if this is no longer relevant, if it's moot by way of being, supplanted by an updated version of this, then that answers my question. I think, Libby is hand signaling us from the back.
Well, the record's.
The
closed
record's
now.
been closed, so.
Okay, so I have a related question to all of this that I want to bring up. And this is only part of the basic picture as I see it, because there's the idea of creating harm here. I'll be honest, if anybody's have to, and this is, I feel it's a fair time to bring this on up. If anybody's had to sit through 50 police visits or more on account of a neighbor that just is disorderly or non-compliant or disagreeable or this or that. I've had property damaged by neighbors before. I've had school kids moving into things and disrupting the neighborhood. I've seen all kinds of stuff for what it's worth, and it can make your life miserable. No question about it. I happen to live in a very peaceful neighborhood right now, and I don't have to trouble with that. But a few miles away from me, they do. And we hear about it from time to time in these meetings. And my question is because we're sitting right in the middle of one of these kind of problems. Is there any resolution to this? Is this going to get better for the neighbors? And this is a question I have to pose to you because you're the property manager. And so that's my question. Do you have any influence over what's going on over there so that this behavior can resolve itself to everybody's satisfaction? And maybe they don't have to like each other, but that the police visits and all this other kind of stuff stop. Is there anything that you can do? And based on all the experience you've had as a property manager and the responsibility you're taking, just so that it doesn't do undue harm to the neighbors for what it's worth, is there anything that you can?
It's fine if you ask the question. I don't believe it's germane to our discussion and our decision tonight. I hear you wanting to ask it as a concerned resident. Is it all right if he answers?
Well, I mean, it's the goose and gander rule here, okay? And so if the record's closed, the record's closed.
Yeah,
And certainly I hear the concern, but as has aptly been stated, there are other ways to deal with those issues. And that's not the issue before the board,
correct.
which, I mean, and I'm not trying to diminish the concern at all. I mean, I certainly understand that, but that's not the issue before you.
Right.
Right, but everybody here realizes that we've spent a half an hour or more, maybe even close to an hour, listening to complaints about the quality of life there. And I realized that from a substantive perspective, that's not what we're attending to here, but it's part of this big picture. And I was wondering if there's any kind of statement that could be made or any type of resolution to this, to people's satisfaction, so that they feel like the future is going to be a little brighter. Because if we do in fact grant these variances, then there's going to be more people there. And I'd like to know that the neighbors who are going to have to put up with this are not going to feel overwhelmed by it.
Well, I think that's putting you in an uncomfortable position, to be quite frank, because you
Mhm.
can never issue those guarantees.
Mhm.
You know, there are mechanisms under the law of nuisance, for example, if someone's infringing on your rights, and I do know from the record that's before the board that those calls were not, I mean, all instituted by the neighbors. Some of them were instituted by the tenants, and people have a right to make these calls. And we're not sitting here in judgment on whether those calls should have been made. I mean, that's unfortunately, we don't have the ability to make people behave.
Right.
And I will say, though, that certainly not everybody can afford to buy his own home either. And so there is a need for rental housing, typically speaking, because not everybody has the money to plonk down. And so I think, as was mentioned at the beginning of the hearing, we don't get to say who gets to rent.
Right.
That's not our bailiwick. I think that certainly Mr. Reaver has been sitting here and has heard your concerns. And quite honestly speaking, I would hope that he would undertake some efforts in response to hearing these concerns.
And that's precisely.
But, and I think that's fine because they have been aired.
Mhm.
You know, I mean, I guess I could have objected and said, excuse me, that's not why we're here. But you know what? This is a layperson hearing. This is,
Right.
and sometimes things that are not relevant do come in. But I
Mhm.
think that Mr. Reaver has heard you loud and clear, and as well as the testimony of the earlier witnesses.
Okay,
So.
thank you.
Mr. Reaver.
Thank you.
For the record, will continue, he has been trying to work on it. He's trying to stay out of trade so he can work with the owner.
Thank you.
Thank you. Okay.
That's
Anything
no more
else?
questions.
No,
Anything
I have,
else, Levi?
no, I have no other.
All right. Do I hear a motion on 135 Chesapeake Avenue
Yes,
and the request for
Diane.
variances? Yes.
I'd like to move to approve the findings of fact and the 5 variance requests as noted in the applicant's Board of Appeals application dated September 15, 2021.
All right, motion made by Wayne,
I'll second.
second by Levi. All right, any discussion?
None, thank you.
No,
All right, all in favor of the motion signify by saying aye.
Aye.
Aye. 3-0. The motion passes. I just want to thank you two for coming in and expressing your opinion, and I hope that this does get better.
So do I. Thank you.
Thank you, Mr. Reaver. Mr. Holsinger.
Thank you.
The meeting of the Board of Appeals. Oh, I hear a motion to approve. I can't do that. A motion to adjourn.
I'll motion to adjourn.
All right.
Second,
Second. The
motion to adjourn.
motion to adjourn.
All in favor, say.
All in favor, say aye.
Aye.
All right.
Thank
Thank
you.
you. The meeting of the Board of Appeals of October 18th is adjourned at 8:37 PM.